Happy New Year, everybody. Thank you so much for joining us. My name is Jie Huang. I am a senior associate at Scott Legal PC. So today we are going to spend some time talking about the E-2 visa requirements with a focus on risky cases, which primarily means cases where the investment amount is low. So just a few things before we get started. Some of you may know the firm was actually founded on an E-2 visa 10 years ago. The founder of the firm applied for an E-2 visa to come to the US to establish Scott Legal. The firm has successfully renewed its E-2 visa as well, so this gives us very deep familiarity and expertise with E-2 visas. Scott Legal is a full-service immigration law firm, but we focus primarily on E-2 visas. We have processed hundreds of them, and we process many E-2 visas that are higher risk, which also mean lower investment amounts. We have processed at consulates around the world, but our primary two consulates are Toronto and London. We will be continuing this webinar series. We're doing at least 2 webinars a month on different topics, so please follow us. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send you all a copy of the PowerPoint that will be used in this webinar. We will also send you a comprehensive guide to the E-2 visa that you can use as a reference. We'll send you a link to where you can sign up for additional webinars coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we encourage you to subscribe to our YouTube channel and hit the notification button as we do regularly upload a variety of immigration law-related videos. Finally, we will also send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case further. As for today's panelists, we are lucky to have Kelly Wiener, who is the managing partner of the firm, who has leading expertise on processing a wide variety of E-2 visa cases. Finally, for any question you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will go ahead and start the presentation and discuss a few things about the E-2 visa. The E-2 visa requirements explained. So generally, the E-2 visa is a non-immigrant visa for investors who are seeking to come to the United States to develop and direct a U.S. enterprise that they invested in. The E-2 visa won't necessarily lead to a green card, but the E-2 visa holder can continue extending the E-2 visa indefinitely as long as the applicant continues to meet E-2 requirements. So someone can apply for an E-2 visa either by purchasing an existing business or the applicant can start up a new enterprise in the United States. Now, let's look at the requirements. Treaty nationality. So the applicant must be a national of what is called a treaty country, which is a list of countries that have the treaties with the United States allowing them to access the E-2 visa. And this person should own at least 50% of the treaty enterprise, which is the enterprise in the United States that they will develop and direct. The investment. You must make an investment, and the investment must be at risk, and the amount should be substantial. So what this means is the funds, investment funds, need to have actually been spent towards the business before applying for the visa. There is no hard and fast minimum, a particular number for what is considered a substantial amount of investment, but it does need to be substantial in the sense that you must have already made all expenditures that is necessary to start the business if you are starting up a new business. Now, there is another requirement, which is that the applicant must be able to show that the funds used for the business have been acquired using lawful means. So this is called a source of funds. The applicant will need to prove legitimate source of funds, such as saved earnings from employment. It can also be from a gift, or it can be also from a loan. The only requirement is that the loan must not be secured by any of the assets of the E-2 enterprise or be secured by the E-2 enterprise. However, it can certainly be secured by other personal assets that the applicant has or be an unsecured loan. So another requirement is that the business cannot be marginal. So what does marginality mean? Marginality refers to the revenue generation potential of the business. So generally, the E2 business cannot be what is called a one-person shop. So which means the profitability of the business must be enough so that it not only just supports the livelihood of the investor and his or her family, but also allow the enterprise to hire U.S. workers. So our recommendation is that in the business plan to project that the U.S. enterprise will be able to hire 3 to 4 employees within the next 5 years of operations. Another requirement is that the business must be real and operating. What this means is that the business, the U.S. enterprise, must be already running or ready to start running once the visa is granted, or if the business is already taking revenue, that is great. So this means the preparation steps must already have been completed. So the entity, the U.S. entity, must be established, for example. There must be business space already must have been leased if it is the kind of business that requires such space. Any required business licenses must have been obtained. And it is also very positive if you already have client contracts for services in place. Another requirement is that the E-2 applicant is coming to the United States solely to develop and direct the business. So developing and directing, it means not only are you coming in to just do productive work on the ground directly to clients, but really the role should be to manage the business and hire more employees to do the work. So the primary duties that you will that the applicant will do would be a managerial leading and directing the business. Now, finally, the final requirement is that the applicant must have an intent to return to their home country after the expiry of the E-2 visa. And this requirement is usually satisfied by a signed statement of the applicant declaring their intent to do so. So we will move on to the next slide, and we'll go into a little bit more detail on the E-2 visa requirements. So E-2 visa requirements, who can apply and how long the E-2 visa lasts for. As noted before, the E-2 visa is a non-immigrant visa, which allows nationals of certain countries to come to the United States to develop and direct the operations of an enterprise in which they have invested. And as I mentioned before, the options are whether you can either start a business or purchase an existing business. Now, what does it mean to be a national of a treaty country? So if you look up on Google, treaty countries, Department of States, you will see a list. And those are the participating countries in the E-2 visa program. This includes a wide variety of countries in Europe, Africa, Asia, Latin America, Middle East. Some examples are the UK, Mexico, Canada, Chile, Philippines, for example. And the list is updated from time to time. So, for example, Israel was added relatively recently for the E-2 visa program. Some notable examples of countries that do not participate in the E-2 visa program: China and India and Russia are 3 countries that do not participate. And there are other countries that do not. You can check on the E-2 visa list by searching the list. Now, what does it mean to be a national of a treaty country? That means having a passport of that treaty country. So this does not depend on the country of birth as opposed to other contexts. So for example, if someone is a dual national of India and Canada, for example, this person could qualify for an E-2 visa based on their Canadian passport. How long does an E-2 visa last for? Right, so the validity of the E-2 visa depends on the country of nationality. And this can be searched if you Google a reciprocity schedule, Department of State. You can click through the name of the particular country, and you'll be able to see what the length of the visa is for that particular country for the E-2 visa. And generally speaking, for many countries, the visa can be issued for up to 5 years. But also for other countries, this validity period can be as short as a 3-month visa. So in this context, it is important to clarify that the length of an E-2 visa is different from the length of E-2 status. which you would obtain 2 years of for each entry when you come into the United States on an E-2 visa. So to reiterate, visa validity period is the length of time during which you're able to travel to the United States with that visa, but it is different from the length of the E-2 status that you are given, which means how long are you entitled to stay in the United States on the E-2 status once you travel to the United States and are admitted at the border with the E-2 visa, which is for 2 years at a time. This period, the applicant can check on their I-94 record, which can be referred to online. So if you have a 3-month valid visa, let's say, you just need to fly into the United States within that time, and you'll be able to remain there and work on developing and directing your business for 2 years at a time since your entry. If you leave the United States after your visa has expired, though, then you will need a new visa to enter the United States again on that E-2 status. All right, so we can move on to the next topic then. How much investment is needed for an E-2 visa? So there is no hard and fast minimum in regulations or law, but the investment needs to be substantial. And what amount counts as substantial will depend on the type of business being started. So generally, to start an office type consulting business, for example, that does not require too much upfront cost to set up all what is needed to get the business operational, this would typically require a lower amount because there are not that many upfront costs to start. So you may need a lease for business space. You may need a computer equipment to, do your work and have meetings with clients. You may need some furniture for the office, but as opposed to other types of businesses, such as manufacturing or a restaurant, for example, the upfront costs would be typically lower for that type of business. In that case, you would be okay with a relatively lower investment. So, for example, by contrast, if you are opening a retail store, for example, this would typically require a higher amount of dollar value for the investment because it typically requires more expensive equipment or larger space to warehouse inventory, cost of inventory, etc. So really, this depends on the type of business that is being started or purchased. So what the government will look at is the proportionality test for a startup, right? So the smaller the total costs needed to set up or purchase a business, the higher proportion of those costs must have already been spent. So for example, let's talk about a small consulting company that only requires up to $80,000 to set up or purchase. The government would expect the applicant would have spent 100% of the $80,000 that is required. By contrast, if you're applying for a 100 million enterprise that is a large retail or technology company, if you spent 10 million in that enterprise, even though you have spent only 10%, you would probably the government would probably think that your investment is substantial because of the total cost is so much higher for that business. Now, what if you are purchasing a business for the E-2 visa instead of setting up a new business? So compare the cost of buying the business to the fair market value of the business, right? So if you bought the business in the open market, for example, you likely did pay the fair market value, and that will be considered a substantial investment for the purpose of the E-2 visa. Another thing to consider is that different consulates around the world have different standards on what they see as a substantial investment, right? So there are some consulates around the world that would consider any amount below 100,000, for example, as insufficient, while other consulates may be open to investments lower than that. So it is definitely important to work with a law firm that understands these nuances so that you are well prepared for your case. All right, so we will move on to the next slide and discuss some strategies to deal with a lower investment amount. So the strategy that we will recommend is first ask what is the overall strength of your E-2 application. If the other aspects of your E-2 case are strong, then you could be okay with a lower investment amount. So, for example, do you have strong evidence of real and operating, that the company is real and operating, that it is ready to go as soon as you're granted the E-2 visa? So, for example, do you have letters of intent or contracts with clients that show their intent to retain the business's services? Do you have purchase orders for products already? Do you have a letter from a local organization, such as a chamber of commerce, that is confirming the need for the business and confirming the projected success of the business? Have you already hired a U.S. employee? And is the business already generating revenue in the United States? All of those aspects can be very positive for your case and could potentially mitigate the risks of having a lower investment amount. Another strategy is really to focus on having a strong business plan and really persuading the reviewing officer of the strong profit generation potential of your business once you start it up in the United States. And as I mentioned before, hiring U.S. employees before you apply, although it is not required, can be a very positive support for your E-2 case. So let's discuss two different examples. So in the first example, let's say you're opening a business, the investment amount is low. However, you already hired 2 U.S. employees and the business has already started taking revenue. And you already have around 10 clients, which you can prove through, invoices, contracts, or other objective evidence of the revenue generation that you have seen so far and the revenue generation potential for the future. Now, this, we would say it is a very strong case. And even if the investment amount is low, we would feel positive about the outcome of the case. Now, by contrast, let's look at a second example. You're applying for an E-2 visa, also with a very low investment amount. You cannot invest any more money, but you also don't want to do any other action in the business, such as you don't want to hire any U.S. employees. You don't have any evidence of interest from potential clients. Let's say the evidence is weak on these other areas. Then when we look at that kind of case, we would see that the profile would be very risky for E-2 approval. All right, so then let's shift gears a little bit and go into a little bit more detail on what is typically included in an E-2 petition with respect to expenditures, which refer to concrete items that you will spend money on when you're preparing to start up a business. So please take a look at this list here. You will see a variety of things that are, typical legitimate investments for business setup. So for example, renting a business office space, purchasing equipment, investing in marketing or advertising. You could also make spendings on licensing fees that is required for your field. Employee payroll setup costs, and also if you already hired an employee, any salary that you did pay those employees, we can also include as part of your business setup costs. Accounting services, for example, so any professionals that you hire to help you start up the business, and any contractors that you pay for services, you can also include that as a part of the investment amount. And what kinds of equipment, for example, can be relevant? So basic office equipment, such as computers, printers, scanners. We see that a lot. Office supplies. If you do have an office space, furniture, such as desks and chairs, can also count as equipment. But really, the practical questions that we're asking is, what does your business need to get to the point of being operational? And the money that you spend to really procure those items would likely be counted in as legitimate expenses for business. And we will discuss a little bit about the differences between good expenditures to include in a petition versus bad expenditures to include. So we'll move on to the next slide. So strong expenditures would really be the bona fide business expenses that I mentioned in the previous slide. For example, marketing expenses, setting up a website for a business, hosting the website. Those are all costs that you can legitimately include because you would need to make those purchases in order to start up a successful business. commercial lease agreement for the office space. And there is an option usually to prepay some rent if you need to boost your expenditure amount. So that is something that we see a lot clients do if they want to show a higher amount. Equipment, as I mentioned before, computer equipment, printing equipment, scanners, always a good type of expense if you are, setting up an office type business and if it is related to your business. For retail businesses, the purchase of inventory can also be a good, strong type of expenditure. Regarding furniture, it should really make sense for a business, right? So those furnitures would need to be typically used for that particular business purpose. So it can't really be anything or everything. So that it needs to have a connection to what your business is actually doing. IP or trademarks, if you are in a business that requires those things, any costs related to procuring those would also be considered strong expenditures. Any money paid to employees and also expenses related to setting up payroll and managing payroll, expenses that you pay to your payroll provider, those can be included as strong expenditure items. Legal fees, if you require professional assistance, either from us or other lawyers to start up the business, prepare a business plan and things like that, you can also include as part of your investment. Business entity setup costs, such as costs of incorporation, costs of setting up those infrastructures, you can add that in. And also licensing fees can be a strong expenditure item. By contrast, what are some examples of weaker expenditures? So travel expenses, we usually recommend clients to exclude those expenses, such as airfare, your plane ticket to come to the US and explore business opportunities and meet clients. We usually would not counsel the client to include the cost of the flight. Similarly, any expenses related to accommodations in the hotel, meals, entertainment, even if it's related to potential client meetings, we would typically exclude those expenditures. And also, if there are some expenses that will eventually be directly reimbursed by a client or a customer. So if you're pre-booking certain arrangements on behalf of future clients, right, and they will eventually pay you back for it, then we would also not include that as part of the expenses that we're counting as investment. Finally, another risky item is any expenses paid to related parties. So if your brother is a web designer and you pay your brother to design your website, that may be a risky item to include in your investment. All right, so now at this point, I will turn it over to our managing partner, Kelly, and she will go over the other topics regarding E-2 visas for risky cases.
Thank you, GA. Perfect. So let's jump into some kind of common challenges and tips for consulting businesses. This is a very common type of business that we process, and there's some particular things to keep in mind when you are going to do an E-2 visa application with a consulting business. So theoretically, a very low investment is sufficient for this. We have many clients that come to us and say, I don't need to spend any money. I have a computer. I have my knowledge. That's all I need. But functionally, to get the visa, you do have to make an investment. And even an investment of a couple $1,000s or $5,000 is just not going to be sufficient to be considered substantial. So what we encourage people to do, excuse me, is to spend money on things that maybe you would pay for down the road. Maybe you don't need a really fancy website, yet. Maybe you plan to do that in year 2, but because it would be helpful both for your company and for the visa application, you would pay that extra money now to get the more developed website at this point in time. You can also think about whether you can prepay for certain items. So for example, office space, sometimes you can prepay for 6 months or even up to a year for some office space. And if it's commercial office space, that can be a very good expenditure. Similarly, equipment, if you plan to hire an employee at the end of the year, perhaps you purchase the computer for the employee now instead of waiting until you hire them. Similarly with employees, if you plan to hire at the end of the year, but you could actually use the administrative assistant now. If you hire the administrative assistant, anything you pay them prior to filing, anything you pay to get a payroll provider set up, to get, insurance related to that, all of those are good E2 expenditures. So even though hypothetically somebody could start up a consulting business without really spending any money, because it is necessary for the E2 visa, you need to kind of think strategically about what can I do to show that I really have invested a substantial amount that shows I'm committed to successfully operating this enterprise. And, we never encourage people to kind of spend money on things that are not needed, but just to look ahead and think about what investments can I make that will be useful for my business down the line, and maybe make those expenditures sooner, so they can utilize it for the E2 application. Let's talk a little bit about challenges for real estate investment businesses. So this is something where on many consulate websites, there's FAQs related to the E2 visa application process. And it's very common to see a question of, can I purchase a house in the United States and get an E2 visa based on that? So consulates are very sensitive to the idea of passive real estate ownership as not being a valid way to get an E2 visa. So like if you own a home or you own a couple properties and you collect rental income from those, that's generally going to be considered passive property ownership. It is not a real and operating enterprise. So consulates are already very sensitive to that. So any type of real estate company that you're doing, you just always go in knowing there's going to be a little bit more scrutiny on the application, because there's many people that work in real estate, but not every real estate type of business really will qualify for the E2. So we have some important things to remember here. So a real estate holding company doesn't qualify. So just passively owning a property, purchasing a property, putting it in the name of an LLC does not qualify. You really need to think about how can you demonstrate that this is going to be an active and operating business that's going to be taking in revenue, that's going to have enough revenue to hire employees, that's going to have activity, beyond just, passively collecting rental income. So some ideas, that have worked, for clients of ours in the past, so one, real estate brokerage, a real estate property management company where perhaps your company has contracts with, other property owners. Maybe the company itself does own its own properties, but also has contracts with other property owners to manage those properties, handle repairs, upgrades, tenant issues, renovation or construction companies. Those can also work. House flipping can work, but only on a large scale. So if you've purchased one home and you're flipping it, that generally is not going to be enough activity to work for an E2 visa. But let's say you have a portfolio of homes that you own. For example, we had a client who owned, 30 or 40 homes that were all going through kind of the renovation process, and all were to be, sold over time. So if you're doing it on a very large scale, that is possible. But of course, that does increase, the costs, right? So if you're doing house flipping on a large scale, then the amount to make a substantial investment is generally going to be, much higher. Another thing to consider in this type of industry is that it's very common that there be kind of license requirements. So each state has its own requirements when it comes to various things like, real estate brokers who can sell homes. If you're going to do construction on a particular level, do you need a contractor's license? So all of these are important things to consider before you apply for the E2 visa. Sometimes people will either, if they don't have those licenses themselves or they can't get them before they enter the US and get a social security number, sometimes they develop partnerships or relationships with people on the ground in the US already who are doing that. So their business has a way to do the activity, before they get their license in place. But it's something you do want to plan for because often they will ask about it. So another very similar, type of business to real estate is kind of E2 visas for equity trading companies. So very similar concerns to real estate in the sense that, some people will try to, place a portfolio or just trade, very minimally for friends and family. And these things generally are not going to rise to the level of being active enough to support an E2 visa application. So if you are going to be in this industry and kind of doing equity trading, you do want to make sure that you have all the proper licenses. It is a very highly regulated industry. You do want to make sure you have a strong business plan that shows, that you will be, engaging in an activity that goes above and beyond just trading for friends and family or working in your own stock portfolio. So kind of very similar concerns to, real estate, and just very important that you have kind of a common sense explanation, because often the officer will not be that familiar, and sometimes equity trading companies can have very complicated structures. You want to make sure that it's very clear, which entity is the operational entity, which one will be taking in revenue, which one will be hiring employees, and making sure you're centering your E-2 application around that type of enterprise. So let's talk about some reasons for E-2 denials. So one is, low investment amount. So, as we discussed earlier, even though for service-based, businesses such as consulting, you can often make an argument for a low investment amount. There will be some investments that are just too low, right? So, if you've invested $5,000, $6,000, even consulates that accept very low investment amounts, or U.S. Citizenship and Immigration Services, they also adjudicate E-2s, and they will often accept very low investment amounts. Even that's going to be too low for them. If this was the reason for a denial and you do have some additional money to spend, one good thing is there are relatively easy ways to fix this, depending on which consulate you're at. So if they say, well, we think you need to spend more money, and you have working capital available, you can spend more money and reapply for the E-2 visa. Another reason for denial, nature of the business. So as we just discussed, there are some industries where officers are going to scrutinize this more closely to see, does it really meet the E-2 requirements? And so some of those that are very common are consulting businesses, real estate, equity trading companies. Another is filing location or venue. So as GA mentioned earlier, although the law is the same everywhere, different consulates take different approaches to what will count as substantial, and there are no numbers in the regulation. So it really is left up to the consulates to determine, what they consider substantial within kind of the legal framework. So there are, and consular officers also rotate, over the years. So there are times when some consulates will start, deciding, well, anything under 300,000 is not substantial. And there's some consulates that are, much more frequently seeing very large companies that are investing and then sending over employees. Those consulates can often be less friendly to smaller service-based businesses, because normally they're seeing investments of millions of dollars. And now if they see an investment of $60,000, it doesn't seem substantial, just based on what they're normally seeing. So it is important to discuss with your attorney to talk about if you do have options for where to file, where may be the best venue for you. So the next two are related reasons for denial. So one is, they're both related to the marginality requirement, which is, will your business create employment in the U.S.? Is it going to be enough to support more than just you and your family? So if you've run a very similar business in your home country for many, many years and you never hired employees, that can sometimes be a harder hurdle to overcome. If now you have a startup, there are no employees, you just have a business plan, they may not believe you because there is a work history that you have that shows you haven't hired anyone. In that instance, it may be better to hire someone before you apply to demonstrate you've already met this requirement. The business will hire employees, and to help, mitigate some of the risk that comes with having a similar business that did not hire employees. Similarly, if there is a concern over whether the business is going to create jobs for U.S. workers, if you have the ability to hire someone prior to filing, even a part-time administrative assistant, that can be very helpful for the application. Another potential reason for denial, issues with the adjudicating officer. Consular officers are people, they're human beings. Sometimes they are having a bad day. Most of the time, our clients will recount that the officers were very polite and pleasant, even if they, ultimately denied the case. But there are times where you have an issue with an officer, you feel you didn't get, a fair adjudication. And one good thing is if you reapply, most consulates will try to give you a different officer. It's not guaranteed, but most consulates will try to have a different person look at the application if it was denied the first time around. And then finally, sometimes, people will apply and they don't meet the requirements yet. So perhaps, let's say if somebody applied and they had a U.S. citizen business partner and they own 30% and the U.S. citizen business partner owns 70% of the company, that company does not qualify, for the E2 because there's not a 50% ownership by treaty country nationals. So, in instances like that, you want to, look back at the requirements. If you don't have an attorney, speak to an attorney, to make sure that when you reapply that you are, able to show that you meet each of the requirements for the E2. Let's talk a little bit about some adjudication trends and hot topics. So, COVID, thankfully, this is starting to be less of a hot topic, and the ongoing impacts are fading, although they are not gone completely. As with many, many different things in the world, visa processing and consulates were shut down for a long time because of the pandemic, and the reopening process has essentially been ad hoc, which means that consulates are reopening at the pace and ability that they have. There is not kind of a uniform or standard reopening that we're seeing. That means there's some consulates like Toronto and London that are basically back to their pre-pandemic, processing levels where they're reviewing the cases, within, the timeframes that they were prior to the pandemic, and people are able to get appointments within a few weeks. There are some consulates that are continuing to be very negatively impacted. Colombia, in Bogota is one of them. In Turkey, there are still very, very, very long delays for e-visas. And because E-2 visas are kind of more specialized and not every consular officer has yet been trained to process them, it does mean that the ramp up to visa processing and starting to process visas again, E-2s are often ones where there's a bit of a longer wait than there was pre-pandemic generally. In terms of whether our consulates processing E-2 petitions, yes, they are. But as I mentioned, there are some that are still extremely backlogged. There are some that have taken much, much longer, to get back on their feet in terms of visa processing, particularly with E-2s. And for those where there's been those really long backlogs, unfortunately, as they work through them, there's continues to be delays. If you have the option, we can talk a little bit about applying with USCIS or applying at a consulate. So if you apply with USCIS for an E-2 visa, that generally means you already have to be in the United States in a valid status. You can't be on ESTA, but let's say you entered on a B visa. And you want to change your status, or you were here on an L and you want to switch to an E, then you can do something called a change of status, where you submit an application to the government from within the United States to show you that you meet the E-2 requirements. So if you get approved, then what you can get is a 2-year approval that allows you to stay in the United States and run the company. It does not allow you to travel internationally, and 2 years is the maximum time you can get it for. Some benefits of applying with USCIS are that, if you're already in the country, you don't have to leave the country. There is no interview. And as well, they will accept much lower investment amounts than most consulates. So investment amounts that are closer to $25,000, $35,000, of course, assuming that it's the type of business that you could realistically support with that type of investment, more like a service-based business. They will accept those lower investment amounts. That being said, they take a much stricter approach to the source and trail of funds than most consulates do. So, for example, if you were applying based on savings from employment at a consulate, at most consulates, you could just submit, maybe your 2 or 3 most recent tax returns, and then proof of you transferring the money to the United States. Whereas if you apply with USCIS, you'll need to submit not only the tax returns, but proof of that money actually entering your bank accounts, being accumulated in your bank accounts. If you transferred it anywhere, you have to follow those transfers. So they will require a very detailed audit of the source of funds. So if you have a complicated source of funds, a complex source of funds, a consulate is often a better option for you. Similarly, some people prefer the consulate because if you do go to a consulate, depending on your nationality, you'll get a visa stamp, and depending on your nationality will tell how long the visa stamp will be granted for. So GA discussed this a little bit earlier in the presentation. It's based on a reciprocity schedule. So what does your home country offer to the US citizens? That's often how they will decide on how long the visas can be granted for. So for many countries, you can get the visa for a 5-year period, and then it's renewable indefinitely. There are definitely some where it's less than that. It goes all over the place. but there are many countries where you can get the visa for, several years, and that will allow you to travel internationally. So for anybody that does need to travel, applying with the consulate is often a better option than applying with USCIS, because when you apply with USCIS, that approval doesn't permit you to travel. And the approval also, it's different than other visa types. So for example, if you get an H-1B and you get an approval, when you go to the consulate is not supposed to re-adjudicate that H-1B application. They're supposed to rely on the approval, check for other, admissibility factors, and then grant the visa. For the E-2, that's different. So when you go to the consulate, even if you've gotten an approval with USCIS, the consulate will review the application as a brand new E-2 application. They are not required to look at the USCIS approval at all or rely on it at all. So depending on your circumstances, it may be better to go to the consulate. I think especially during COVID, we saw many people kind of extending their E-2 status from within the US because of that inability to travel. So it is possible, but it does come with some downsides, such as you're not going to have a visa stamp that allows you to travel internationally. Let's talk about some complex areas that can come up with E-2s. So a very common question is, do I have to hire employees before I apply for an E-2? And the answer is no. There, again, as always, there are some consulates that might take a different position, particularly, right now, anecdotally, we're hearing, the consulate in Taiwan, kind of sometimes will take the approach there needs to be employees, before you can be, granted the visa. But that's, our general experience with most consulates around the world and with USCIS, and what's required by the regulations is that you do not have to have employees before you apply. What you do need to show is that the company has the ability to make a significant economic contribution within 5 years of starting. So generally, this is going to be shown by a 5-year business plan that provides, an outlook on, profit and loss statement, 5-year balance sheet, and a 5-year hiring plan. It's very beneficial to your case if you can hire employees before you apply, but it is not required. Some other complex areas, are source and trail of funds. So this is particularly the case for USCIS filings. As I mentioned previously, they will require an audit of exactly where every dollar came from. And so you do need to be prepared to provide that documentation. And if it's documentation where, well, I received the money from my mother and it went back several years and she had an inheritance and we don't have the paperwork, for USCIS, oftentimes that will not work. They will require that trail. You do have to have that documentation in order for them to determine that there is a legitimate source of funds. Whereas the consulates often will take a much more high level view. Some consulates will ask for more information. You do need to have a legitimate explanation, but that dollar for dollar accounting of where every, penny went, really USCIS is the one that's really asking for that. People often ask about loans. So loans and gifts are both acceptable as sources of funds for E-2 investment. For loans, I think as Gia mentioned, the important thing is just that the loan cannot be secured by the assets of the E-2 company. So they want the investor to be personally on the hook for the loan. So for example, if you own your home and you take a home equity line of credit, you can utilize that as your E-2 investment. That's completely fine. For gifts, generally you're going to have a gift letter, but then you also need to go beyond that and get documentation from the gift giver as to where they got the money. So if you are getting a gift, and particularly if it's a USCIS filing, you need to make sure that the gift giver is comfortable providing very detailed financial documents, tax returns, anything that's necessary to prove where they received the money. Other things, E-2 visas for 2 investors, people will ask, can they have a business partner? The answer is yes. It's also possible to get two E-2 investor visas for a business owned 50-50, but both people individually need to meet the E-2 requirements. So there needs to be a substantial investment from both sides, and there needs to be an agreement that shows that each has the ability to develop and direct the company. So with that 50-50 ownership, that is generally permitted. But another structure would not, for example, 60-40, that would not work. There does need to be an ability for each side to develop and direct the company and to independently meet the E-2 requirements. Another issue that comes up a lot are substantive changes to the E-2 business after filing. So sometimes people, are under the impression that they get their visa and their visa is granted for many years, and that kind of no matter what happens with the company, they can continue to work in the United States. And that's not the case. So when you are getting your E-2 visa, you are being given permission to develop and direct the company that you described, to the officer and showed that you met the requirements, and you need to continue to meet those requirements to be able to continue using the visa. So, for example, if something changes in the ownership and the company is no longer 50% owned by treaty country nationals, or you no longer own the company, or you no longer have operational control, at that point, your E-2 is technically no longer valid. And it may be nothing will automatically happen. But if you continue to come to the US and to work on that visa, even while you technically no longer qualify, you will be out of status. And when you go to renew or you try to get another type of visa in the future, it could be very, very problematic. Similarly, if there's a change in the type of business, and it's a substantial change. So, for example, you were, a wedding photographer, and now you decide you want to shut that business down, but under the same LLC, you're going to start a restaurant. So these are completely different business lines. And if nothing was discussed about, in your initial E-2 visa application that you were going to run a company that was both wedding photography and a restaurant, you're not permitted to start running the restaurant until you get a new approval. So that could look a few different ways. One is you could go back to the consulate and submit a new application. Another is that if you're already in the United States, you can submit paperwork to USCIS and say, I am notifying USCIS of a substantial change and I want to get an extension of status, and have you, approve this substantial change. But the important thing is to get that approval before you start the new business line. If you go ahead and you start, a completely different business line, without getting that approval, again, you've technically fallen out of status. This could become very problematic at the renewal stage. If it's really not a substantial change, let's say it was a wedding photographer business and now you're starting up a blog where you're going to talk about specific wedding topics. This seems like it's not a substantial change, right? Like if something can be framed as a natural outgrowth of what your business is doing, that's not something where you need to go back to the consulate. So if you were going to have a marketing consultancy and your niche target was going to be financial firms, but then you found out that actually clinicians and therapists were a much better fit for your niche, and then you worked with those types of clients, but you're still doing marketing consulting, that's fine. This is not a substantial change. You're still doing the services that you outlined in your business plan. So if you do have any question in your mind about whether a change or a different direction you want to take your business is going to be a substantial change, you want to speak with an attorney before you make those changes to make sure you're not violating your status. Another thing that could come up are family business purchases. So relatively common if somebody's wants to buy into a business, wants to buy a certain percentage of a business, perhaps they're buying it from a family member. It is possible to do this. It's obviously better, stronger for the case if you're, buying it from someone who's not related to you. But if you are buying it from a family member, then, there's going to be more scrutiny on whether the price that you pay for the business is really the fair market value. So what you want to do is potentially get a valuation done, have a CPA write a letter. The financial statements that are available should reflect, the purchase price in relation to those financial statements should make sense. So if the business, the financial statements show the business is, worth a lot, very high assets, very low liabilities, high equity, and you're paying a very, very low amount, much more likely you're going to get scrutiny over whether that investment is truly substantial. So getting that CPA value, letter, or getting a valuation on the value of the business to show that what you've paid is the fair market value is going to be recommended in cases where a family business purchase is happening. All right, so we now can take some questions. I think a couple have come in. So Gia, do you want to take this first question?
I will take the first question. So for E-2 investors who want to create his or her own enterprise, how can we support the real and operating requirement? So so basically what it means for a startup is that everything necessary to get the business up and running should have been acquired, right? So we like to discuss the example of a gym, right? So there was an applicant who went to the consulate, did the interview, was planning to start up a gym. And at the interview, the consular officer asked, okay, if I go to the address for your business and open the door, what would I see? And then the applicant answered, oh yeah, you would see all of the equipment. I've already purchased them. It's already been set up. All of the, equipment that I need to, make payments and things like that has also been set up. So all it needs is for me to just open the door and start working. Everything is ready. And that was the answer that the officer was expecting. So that example really illustrates that a variety of things, anything that really you need to get the business operational should already have been acquired. This could, include things like setting up your U.S. Corporation entity, LLC, also setting up a U.S. bank account for your business, having office space leased up if that is if you require office space, having your business website up and running if you do online marketing for your business. All of these infrastructures would have to be ready by the time you apply at the consulate, and even better if you already have client contracts lined up. So those are some of the ways you can meet the real and operating requirement.
Perfect. I can take this next one. Can we hire an E-2 executive employee from our country of nationality who has qualifications but no managerial experience? So, I mean, generally, like the requirement for an E-2 employee is that, they have to be the same nationality as the owners of the E-2 company. If the owners of the E-2 company are also in the United States, they themselves also need to be maintaining E-2 status. But assuming they're not, let's say they're not in the United States, I mean, the answer is yes, you can bring over, you can make an argument as to why this employee, has the skill set to do executive work, even if they have not worked in a managerial role before. But there could be more questions. It could be harder to make the successful argument, as to why they're needed to kind of start up the company if they don't have experience, in that field. So it isn't a requirement that you've done the exact business before, that you've held an executive or managerial role before. If you're an investor, but if you're an E-2 employee, they're going to scrutinize your resume and your work experience much more closely. So there should be some type of nexus between the job that they're coming to do and what their work experience would, inform their skills and qualifications to be able to do. Someone's asking, does purchasing a franchise count as purchasing a business? Is this a good case for an E-2 visa? So yes, it is possible to get an E-2 visa through purchasing a franchise, either an existing franchise, or if, you're just going to sign a franchise agreement and start up, a new territory, that those are both good options. The only thing to keep an eye out for with franchises is that some franchises don't permit, or some franchises really have a very tight grip about what you're allowed to do. And we haven't seen this be a major issue, but unless the franchise agreement is extremely aggressive. But it is something to keep in mind, because you do have to have the ability to develop and direct the company. And if they feel that you don't have the ability to do that because the franchise agreement doesn't permit it, that can potentially be problematic. But most of the time, franchises are quite good because they're proven business models. There's often lots of support, and so they can be very good options for E-2s. Okay, so let's see. There's for a business that's already running with inventory and equipment and a website, how can there be a substantial investment? So it depends. It really depends. So let's say that if you're purchasing a business, you're purchasing a portion of the business, then it's just, it's a purchase sale agreement for either shares or assets. If it's a situation where you've owned this business, we would often look back to see, what did you invest when the business initially started? So can we look back, and was there any initial investment, at the time the business started to operate? And if none of those things are, available, if there wasn't any investment in the beginning, or it's not a purchase situation, then oftentimes we'll have advise the investor to make a investment now. So to make a new investment into the business that essentially is then used on things like payroll, commercial, office space, if there is, payments that need to be made for inventory. So there's a few different, it's a more complicated situation. It can be more, complex to try to prove the investment, but there are different strategies you can use, even if the business is already operational.
All right, so it seems like those were all of the questions that came up. Maybe wait a few more seconds for any others that may roll in. doesn't appear to be any more. So we will close here. Thank you everybody for your participation and for joining us today for this webinar. And yeah, Happy New Year to everyone.
Happy New Year.